The power to convene company meetings is allocated among several parties depending upon the circumstances and the nature of the business to be transacted. In most cases, the Articles of Association delegate authority to the Board of Directors to call general meetings whenever corporate business requires shareholder approval. This reflects the directors' responsibility for managing the company's affairs while recognizing that certain decisions must ultimately be made by members. Shareholders also possess statutory rights to require a meeting to be convened. Members holding at least 5% of the company's paid-up voting share capital may formally require the directors to call a general meeting, GM. Once a valid request has been received, the directors are required to call the meeting within 21 days, and the meeting itself must take place within 28 days of the notice convening it. These provisions ensure that minority shareholders possessing a significant economic interest can require important corporate matters to be considered without depending solely upon the willingness of directors to act. If the directors fail to comply with this obligation, the requesting members are granted an important statutory remedy. The shareholders who initiated the request, or any members holding more than 50% of the total voting rights, may themselves convene the meeting, provided it takes place within 3 months of the original request. Any reasonable expenses incurred may be recovered from the company, reinforcing directors' obligation to respond appropriately to valid shareholder requisitions. Additional parties may also require meetings in exceptional circumstances. A resigning auditor may require the directors to convene a meeting in order to explain the reasons for resignation where circumstances connected with the resignation should be brought to members' attention. Furthermore, the court may order a meeting to be convened where it is otherwise impracticable to do so, such as where corporate deadlock prevents the normal operation of governance procedures. Notice: the validity of company meetings depends upon compliance with statutory notice requirements, which ensure that participants receive adequate information and sufficient time to prepare for the matters to be considered. Under Section 310 CA-06, every member and every director must receive notice of a meeting. However, under Section 313 CA-06, the accidental failure to provide notice to one or more persons does not invalidate the proceedings, thereby preventing minor administrative errors from undermining otherwise valid corporate decisions. The notice itself must contain several essential elements. It must specify the date, time, and place of the meeting, together with the general nature of the business to be transacted. Where a special resolution is proposed, the full text of the resolution must also be included so that members understand precisely the matters upon which they will vote. These disclosure requirements promote informed shareholder participation and procedural fairness. The minimum notice period depends upon the type of meeting. An annual general meeting, AGM, requires 21 days' notice, although a shorter period is permitted where every member entitled to attend and vote agrees. A general meeting, GM, ordinarily requires 14 days' notice, although this may be reduced where members holding at least 95% of the shares agree, or 90% in the case of a private company where the articles permit such reduction. Certain matters require special notice of 28 days, including the proposed removal of a director or auditor, reflecting the importance of these decisions and the need to protect procedural fairness. Resolutions. Company decisions are implemented through resolutions, the type of resolution depending upon the importance of the matter concerned and the level of shareholder approval required by legislation. A special resolution requires the approval of 75% of votes cast and must be filed with the registrar within 15 days. Special resolutions are required for significant constitutional matters, including alteration of the company's name, alteration of the Articles of Association, reduction of share capital, and voluntary winding up of the company. The enhanced majority requirement protects shareholders against fundamental changes being approved by a narrow majority. An ordinary resolution requires a simple majority of votes cast and is used whenever legislation or the articles do not require a special resolution. Common examples include the appointment of directors and auditors, declaration of dividends, and routine corporate administration. Filing with the registrar is required only where expressly provided by statute. Private companies may also utilize written resolutions, avoiding the need for a physical meeting. Such resolutions require the same majority that would apply at a general meeting, cannot be used where special notice is required, and become effective once the necessary majority has been obtained. Members cannot subsequently revoke their agreement, and the resolution must be passed within 28 days of circulation. Procedure at meetings. The conduct of company meetings is governed by statutory rules designed to ensure orderly decision-making and democratic shareholder participation. A meeting may only transact business if a quorum is present. Under Section 318 CA-06, the quorum is generally 2 persons, either members or validly appointed proxies, unless the company's articles provide otherwise. Voting ordinarily takes place by a show of hands, under which each member has one vote regardless of the number of shares held. However, a poll may be demanded by members holding at least 10% of the total voting rights or by not fewer than 5 members entitled to vote. On a poll, each share carries one vote, ensuring that voting power reflects economic ownership. The result of the poll replaces the result obtained on the earlier show of hands. Quoted companies are additionally required by Section 341 CA06 to publish poll results on their website, enhancing transparency and shareholder confidence. Finally, Section 324 CA06 grants members the statutory right to appoint one or more proxies to attend, speak, and vote on their behalf. Proxy voting enables shareholders who cannot attend personally to participate fully in corporate governance while preserving the representative nature of shareholder decision-making. Collectively, these procedural rules ensure that company meetings operate efficiently, transparently, and in accordance with the principles of fairness.